SJC-12010, Commonwealth v. Eddie G. Teixeira-Furtado.
Good morning, Ms. Lewis. Just give us a
Good morning.
moment.
Yes,
We've solved our microphone problem, we think.
thankfully.
We turned it off.
For all of us.
All right, you may proceed.
Good morning, Your Honors. May it please the Court. Sarah Lewis on behalf of the Commonwealth. We are asking this Court to reverse the motion judge's decision in this case, allowing the defendant's motion to suppress. The crux of the issue in this case is the lawfulness of the motor vehicle stop. Reading from page 1 of the Commonwealth's appendix, which is the motion judge's decision, the motion judge explicitly found that the officers observed a car traveling at a speed greater than reasonable in a residential area with plenty of kids around. She credited these facts, which are supported by the testimony and are not clearly erroneous.
The area was one that had plenty of kids around. I don't think that she found that at the time there were plenty of kids around.
I understand that. Her findings are that the area is a residential one with plenty of kids around.
This was at
There's
night, so
7:45 at night, so not potentially unreasonable, although it was in November. But this is the context of the area, and that context is important here as a factor that she found.
So was there a posted speed?
Not on the record. We don't know the.
But it's a
posted speed.
residential area. The law of the road, 25 miles per hour in a residential area?
The officer did testify that his understanding that in this area the speed limit was 25 to 30 miles an hour. The motion judge did not explicitly include that in her findings, although I would suggest that she did credit that. She begins her findings by saying that.
Just stated it as this is what he said.
I'm sorry, Your Honor.
This is what he said.
The officer Noto did testify to that fact.
He made that statement.
Yes.
That he didn't know the specific amount, so it was somewhere between 25 and 30. It could have been 30 because it's thickly settled, but we don't know.
Exactly, and I think that's an important consideration. I don't think we need the speed here. It's irrelevant where we have the officer's observation, although I think the inference can be drawn where he's aware of the speed in this area and he testifies to the fact that the car is traveling at a speed greater than reasonable. The inference would be that it was over that speed limit.
1 mile an hour over?
Regardless, it was his
anything from the fact that he's quoting directly the statute?
No, I don't think. I think that quotation, first of all, the motion judge's quotation of that, or him quoting it, is a red herring. He's aware of the statute. He testified to the exact statute, Chapter 90, Section 17, and he's aware of this language, and that was his observation, and that's the key part of this. It's not a conclusion. It wasn't his belief. He observed that the car was traveling at a speed greater than reasonable, and as the appeals court noted in its opinion, interestingly, in a footnote 2, it's Commonwealth's addendum, page 18, a police officer's observation of a civil motor vehicle violation, such as speeding in violation of Chapter 90, Section 17, provides justification for an initial stop.
But let's assume it's reasonable. The term is reasonable articulable suspicion. What is articulable about the assertion that a person was going faster than reasonable?
What is articulable in this? It's his observation, and the fact that the motion judge credited that observation, and the inquiry should end there. I would suggest that the other factors that he testifies to, that it's a residential area, there's kids around at times, provide context to the fact that...
Does it mean that he has to express an opinion that the speed was approximately 35 miles an hour, which is greater than reasonable and proper?
No, I think that we don't have to. The Commonwealth does not have to prove the violation in this case. And where we don't have to prove the violation, his observation suffices. I think that...
I mean, on that theory, just to pick up on what Chief Justice Gans is saying, I mean, what do we have here other than a conclusion? His driving fits within the statute. That's my conclusion. I mean, is that enough? What's articulable about that?
Driving in violation of the law.
I think that it's not a conclusion where he testified, I observed that this car was traveling at a speed greater than reasonable, and the motion judge credited that finding. The motion judge
You
could,
keep saying credited that finding. What is the finding part here? The motion judge wasn't saying she credited anything he said about it being a fact. She said, in fact, that the defendant's point is well taken. You know, she's saying, look, and in the footnote, this vehicle couldn't even been driving except quite slowly. He was going up a hill. All he's saying is, I think you broke the law. I mean, what kind of finding is that?
Well,
I don't think she's making a finding, even though I know you say it is, but I don't know. I don't see that it's a finding of a fact. It's a finding that he made a statement that amounts to a conclusion.
I would point the court's attention to, again, the Commonwealth's addendum, page 1, where the motion judge says, in her findings of fact, which she prefaces by saying, I find from the credible evidence the following.
Correct.
She says 15 minutes later, the officers were on Bentham Road close to a stop sign facing Mount Ida when they observed a car traveling at a speed greater than reasonable. And then on page 2 of the Commonwealth's addendum into page 3, she says a careful inspection, she being the motion judge, a careful inspection of the record provides the following facts in support of the stop of the vehicle. The last one being the vehicle was traveling at what was perceived by the officers to be an unreasonable rate of speed. I think that Your Honor's concern might come from the fact that later she says a mere statement that a vehicle was traveling at an unreasonable rate of speed does not suffice. But I would suggest that is improper, that she credited the facts, and that should end the inquiry.
She credited that he said it. That's why she quoted it. And then she concluded otherwise.
She also quoted other parts of his testimony, such as plenty of kids around, and I would suggest that she was potentially quoting the statute just as much as he was quoting the statute. I think that if this court were to not find that this suffices to, or this does not amount to reasonable suspicion to stop the car in this case, we'd be setting back decades of precedent which allow an officer, based on their visual observations, to stop a car for a motor vehicle or a traffic violation.
So if somebody stops at somebody on the street and said, I had reasonable suspicion to stop Miss Lewis, and the judge, that's all you need to say?
No, I don't think that we have that in this case. I don't think the officer just said, I have reasonable suspicion. The specific and articulable facts that support the reasonable suspicion in this case is his observation. I think this is similar to cases like Commonwealth versus Baez, if I'm pronouncing that correctly, which is an appeals court case regarding tinted windows. And the court says it's well established that where the police have observed a traffic or motor vehicle law violation, they may pull over the vehicle. The court goes on to say, we think the standard to be used in determining the legality of a stop based on a suspected violation of the tinted window statute, chapter 90, section 9D, is whether the officer reasonably suspected, based on his visual observations, that the tinting of the windows exceeded the permissible limit of the statute. And I think that's what we have here. We have the officer's observation, his visual observation, in his training and experience. He's familiar with this area. He testified that he's from Dorchester. He's driven on Mount Ida Road before. It's a residential area. He's familiar with the speed limit, and taking all that into account, he observed this car traveling at a speed greater than reasonable.
The problem, let's step back from this.
Yes,
We have a problem with pretextual stops.
understood?
How does a judge evaluate whether this is a pretextual stop when all the officer says that he was traveling at an unreasonable rate of speed? I mean, that's what the judge is concerned about, is anybody can say you're traveling at an unreasonable rate of speed, and if that's all you say, how can the judge evaluate whether or not there truly was a violation?
Well,
Or a ground to suspect a violation.
right. I would first just point out the fact that the motion judge, there's absolutely no basis in the record in her findings to find that the stop was a pretext here. And her concern was that this mere statement wasn't enough. Her concern wasn't about she didn't discredit the officer. And I think that's the important distinction here. She didn't find it was a pretext. She didn't discredit him. And it's up to her to assess his credibility when he's on the stand listening to his testimony.
Is a reasonable rate, whatever it was, a reasonable speed greater than reasonable,
mean that it's a speed greater than the speed limit? Or within the context, it could be if the speed limit is 25 or 30, which is what he testified to, but there were children around and he was doing 20, that might be too fast. But we don't know any of that.
Well,
We don't know why he thought this was a speed greater than reasonable.
I understand your concern. I would just to answer the first part of your question, the statute does not require, we're not required to prove a violation of the statute. I see him over time. May I answer your question? But the statute specifically says, no person operating a motor vehicle in any way shall run it at a rate of speed greater than reasonable and proper, having regard to traffic and the use of the way and the safety of the public. So you're correct that there's not a speed limit requirement. Here, we have context. He provided context by talking about the residential nature of the road, his familiarity with the area, his experience, training and
What time was this? I know it was night, but what time?
7:45 p.m., I believe, which I think is relevant as well. And therefore,
Remember, so probably the kids weren't going to be out playing in the street at that.
potentially not, but that is a relevant factor to give context to his observation that
So we
this-
don't know what that's, so we don't really know whether he was right.
I think we know that the motion judge credited his observation, and the inquiry should end there, where
We know
that,
Well, she
said-
noted his observation,
Noted
but
it.
said it's not sufficient
but it's
in these
included.
circumstances without any support. It's just not sufficient.
I respectfully read her findings differently. The facts are included in her findings, and again, she prefaces them by saying, I find from the credible evidence the following. That's a factual finding that she found, that she credited, and that's within her discretion as a judge to do.
But without any specific articulable objective facts to explain that conclusion, and which would permit the court to decide whether the stop was justified, would amount to a rubber stamping without further, I mean, okay, she said, yes, that's what the officer testified, but provided no basis for that conclusion, and that's not sufficient.
I think that the basis is his observation, and rubber stamping would be where a judge credits everything or does not assess credibility. But here, that's not what happened. I think that the problem is her legal standard that she applied, not the...
Wanting to know the underlying reasons for the conclusion?
And I think that the case law of this court and the appeals court show that the observation of an officer is sufficient to amount to reasonable suspicion to stop for a traffic violation.
So if an officer says, you know, I was walking on the street and I saw an African-American male and it was dark and it's a high-crime area, and so I stopped him because I reasonably suspected that he was carrying a firearm, period. Is that enough?
No, I think well,
Reasonable?
if he gives details to his observation,
Well, but this guy didn't either. I mean, this officer
but
didn't.
this is a different, I would suggest this is a different context. The specific and articulable fact is the officer's observation of the traveling at a speed greater than reasonable. In your hypothetical, if the officer, based on his training experience, observes a person walking down the street with holding his waistband, actually, as we have in this case, and he believes, based on his training experience, that he's holding a firearm, then yes, that would be sufficient to stop. But this is a traffic violation, and I think it's distinctive.
All right, thank you.
Thank you.
Still morning, Ms. Kiley.
Yes, good morning. May it please the court. Rebecca Kiley on behalf of Eddie Teixeira-Furtado. This case does involve the application of a very basic principle of suppression law, which is that in order to establish reasonable suspicion, the Commonwealth has to present some specific and articulable facts justifying the stop. And Judge Ford correctly determined that an officer who simply, even if repeatedly, parrots the statutory language of Chapter 90, Section 17, that does not satisfy the standard. This officer appeared to be literally unable to articulate the factual basis for the stop.
But when you say that, though, he didn't. But why do you say unable?
Well, because he was asked at least 3 times
What was the basis?
what were your observations of the car? And he kept saying traveling at a speed greater than reasonable. And I think it's very possible to imagine any number of specific facts that he might have asserted.
Well, maybe the question it just wasn't a good question.
Well, perhaps in that case, it is the Commonwealth's burden of proof to elicit the evidence.
But
and to do so.
do you agree that the law of the road, Chapter 89, I don't remember the section, says that if it's not posted in a residential area where houses are less than a quarter mile apart, that I don't remember if it's exactly a quarter mile, but the speed limit is 25 miles an hour.
I disagree.
What is the law of the road?
Under Chapter 90, Section 17.
No.
But which
Chapter-
does set the.
Go ahead.
Well, I'm sorry, I'm not familiar with Chapter 89, and so I may be mistaken. But Judge Ford found, and I think she was correct, that under Chapter 90, Section 17, in a thickly settled district that is not a school zone, the speed limit is 30 miles an hour.
Okay, so it's 30 miles an hour.
so it's 30
Isn't it
miles an
implicit
hour.
here? Isn't it implicit that from the officer's testimony that in his opinion the person was going at a rate of speed that exceeded 30 miles an hour?
No, for two reasons. The first is that the officer erroneously testified that the speed limit was 25 to 30 miles an hour. And Judge Ford, I think it is clear that she did not credit that because she didn't include it in her findings, and she correctly noted that the speed limit is 30 miles an hour. And so, in a different case where an officer testified that the speed limit was 30 and the car was speeding, I think it would be open to the judge to infer that the car was traveling at over 30 miles an hour. But that's not what the testimony was here. It was just repeatedly that the car was traveling at a speed greater than reasonable. And it's possible that what he meant was it was going more than 25 or 30 miles an hour. But it's also possible that what he meant was, given the traffic pattern, this was too fast. The other cars were going slower. He might have meant there were pedestrians around and it didn't seem safe. Or he might have meant because of a police detail on the corner, he needed to slow down. But we just don't know because he didn't say.
But would you agree, though, I know it's not this case, but if he'd said something like, my estimate he was going 25 miles an hour, but for A, B, and C reasons, that was not reasonable. That would be okay. In other words, it isn't just that it's not over 30.
Right.
You would agree?
Yes.
that
I think it's clear under this.
Question, reasonable is going to be completely
Yes.
contextual.
Right, if
Could
it
be
was a
more.
blizzard, you can't drive 30, even though that's the general speed limit. But he would have to give the judge some factual basis on which she could determine whether she agreed that there was reasonable suspicion that the car was traveling at a speed greater than reasonable. And that just didn't happen here.
I don't know how to take the footnote at 3 when the judge notes, I assume that was part of the record on the motion to suppress, that there was evidence that the distance traveled by the offending motor vehicle was at most 318 feet from a required turn at the end of that street from where it was observed, and it was going uphill before it was seen.
Right.
That was part of the record?
It was based on the testimony of a defense investigator. And it was presented, I think, because Chapter 90, Section 17 makes it prima facie evidence of a violation to exceed the speed limit for more than 1/8 of a mile. And so it was presented to rebut any prima facie case because they didn't observe the car for 318 feet.
As opposed to 650 or
Yes, so,
something.
right, thank you. They did not observe it for 1/8 of a mile.
Of a mile, whatever, yeah, 650.
Okay. Unless there's anything else, we will thank you.
Thank you.
Thank you.